let's talk about Starbucks versus McKinney. It's interesting because Starbucks is now sitting down and negotiating with its union. But the National Labor Relations Board had found that they had engaged in unfair labor practices, specifically in the firing of some employees who were organizing. And the question here is whether courts must evaluate the National Labor Relations Board's requests for injunctions. And I guess the injunctions have to do with stuff like firing and whatnot, right? Whether the courts have to impose a four-factor test or some other more lenient standard. What does that mean exactly?
Yeah, so when the NLRB senses an unfair labor act, they will file for an injunction to basically maintain the status quo at those businesses while they sort out whether or not there was, in fact, in their opinion, an unfair labor action. So if someone was fired and they think that that was a violation of the National Labor Relations Act, that person would be reinstated while they sort it out. And the idea is that if you don't do that, if you just allow someone to be fired, for example, then by the time everything is resolved months and months later, the damage has been done to the organizing effort, right? That's where the NLRB gets their authority here. So what this
ironically,
is about,
that's what the right wing on the Supreme Court argued would happen if they enjoined the Florida recount, that there would be a presumption that George Bush is not president in some fashion. But go ahead.
Right. This is about what standard is used in those injunctions. Basically, right now, there's a very low standard that a court will, at least in some circuit, there's a circuit split about this, but in some circuits, in some federal circuits, there is a standard where if the NLRB comes to them and says, we want an injunction, they will grant that injunction unless they think it's frivolous. That is a much lower standard than your standard injunction, where you basically have to prove what's called a likelihood of success on the merits, basically meaning you're more than 50% to win this case in the eyes of the court, which means that when most people go for an injunction in court, you're sort of litigating the whole thing right off the bat. You're saying, we're going to win this, right? And the court's saying either yes or no. And that sort of dictates where you are. So the NLRB has operated with this lower standard, at least in some circuits, for a good amount of time. And Starbucks sort of thought, hey, why don't we say that this is unfair? And I think the court's going to buy it, because it seemed like Starbucks had the liberals on their side to some degree, at least with the idea that the standard needed to be raised. Not KBJ, but there's only three of them, so all three isn't enough, let alone just one. But you're right. I mean, Sotomayor and Kagan were just a little more skeptical, I think, of the NLRB position than they would be if they were ready to just go all out and draw a line in the sand on it. And I think that this is the type of case that the conservatives love. Hard to explain to the average person, right? It's hard for the New York Times to get a punchy headline about this. It's about injunction standards at the end of the day. And it undermines the authority of the NLRB, which they truly love to do.
Yeah, how much of this is like part of the whole Chevron doctrine assault and the non-delegation assault? I mean, I guess I wasn't necessarily aware that the NLRB had to get a court to sign off on these things each time they imposed a penalty or a constraint in these situations, because this is going to become increasingly relevant, both in the sense of like in the wake of the Cemex case, where unionization is basically imposed if there has been, the National Labor Relations Board finds that there's been unfair labor practices in the context of an anti-unionization effort. And then there's a lot of people who hope that the National Labor Relations Board is going to say, we're going to arbitrate a contract if, you haven't gone into contract within, I don't know, 6 months, a year after unionization. That's on its face an unfair labor practice. Therefore, we can impose a contract on both parties. All of that seems like, this feels like a string that's being pulled to go after those big prizes.
Yeah, I think that's right. And I do view this as sort of part of the non-delegation project. The NLRB gets all of their power from the National Labor Relations Act, which is in some ways, you could characterize it as a vague statute. I think I would characterize it as a broad statute rather than vague. But I think conservatives have long thought this is all a little too vague. And the whole purpose of the sort of non-delegation doctrine is to clamp down on that sort of vagueness and basically just read everything as narrowly as possible. So if you're not getting express authority for something from the NLRA, then you can't do it. That has been like part of the conservative project, Read the Administrative State, for a very, very long time. And I think they see the NLRB as something they can sort of pick apart steadily. You've had these relatively fringe theories come up that the whole project is sort of unconstitutional, that the composition of the NLRB is sort of functionally unconstitutional. I don't think those are particularly serious, but I do think that the conservatives are very willing to look at any given part of the NLRA and just read it narrowly. And if you do that enough times, the NLRA becomes very, very weak.
All right. Well, I guess we'll find this is another one we're going to have to wait until, I guess, June or maybe early July.